When you're charged with driving while under suspension in Ontario, you're facing serious penalties which can dramatically impact your life. Now, here are 5 things that you need to know about the penalties. First, here's a list of the penalties that you'll be facing. First, there's a driving license suspension that will last you 6 months. Unfortunately, this is a mandatory part of the penalty. Second, there are fines that range from $1,000 to $5,000 plus a 25% victim surcharge. Third, there could be probation up to 2 years. And fourth, there could be jail up to 6 months. The second thing you need to know is the 6-month driving license suspension. That actually is mandatory. Now, if you get convicted of driving while under suspension in Ontario, you will lose your driver's license for 6 months. There are no exceptions to this rule. The 6-month driving suspension is written in the law. So even if the prosecutor or let's say the justice of the peace, let's say they have sympathy for your situation, unfortunately, it doesn't matter. They do not have the power to remove the mandatory 6-month suspension. The third thing you need to know is that the penalties are a range and not fixed. So other than the mandatory 6-month driving suspension, the rest of the penalties are defined by the law as a range and are not fixed. So, for example, the fines range from $1,000 to $5,000, and there's a potential of jail time for up to 6 months or probation for up to 2 years. Now, what this means is that the lawmakers that wrote the law, they want to give the court the discretion to apply the penalties based upon the specific facts of your case. So the more serious the fact situation, so for example, if you have prior convictions of driving while under suspension, or there was an accident while you were charged with driving while suspension, the more serious the penalties will be. The fourth thing you need to know is that the justice of the peace decides. So if you're convicted of driving while under suspension in Ontario, the prosecutor will be seeking a penalty based on the ranges that I just outlined. But the final decision maker on the penalty is the justice of the peace. So even if you've negotiated a plea agreement with the prosecutor about your case, that agreement must still be approved by the justice of the peace. And sometimes those negotiated deals do not get approved. Finally, the fifth thing you need to know is that you may be able to get out of the mandatory 6-month driving suspension. Now, while the 6-month driving suspension on conviction is mandatory, it may be possible to avoid the suspension, and here's how. First, if there is a big error in the evidence that the police are going to use against you, then it may be possible to get the charge withdrawn. Second, if the evidence against you is not strong enough to support a conviction, then the charge may be withdrawn. Or third, if you can convince the prosecutor that it's, quote, not in the interest of justice, and this is a legal test, by the way, that it's not in the interest of justice to pursue the charges against you, then it may be possible to avoid the charge itself, which means you'd be able to avoid this 6-month driving suspension. Reach out if you have any questions.